Good afternoon. My name is Neil Siegel, and on behalf of the program in public law here at Duke Law School, I welcome you to our annual Supreme Court preview. We had the review recently of the October 2008 term, and yesterday officially began the U.S. Supreme Court's October 2009 term. Just to situate the present term for you, the justices at the end of June disperse for the summer, and over the summer, literally thousands of certiorari petitions pile up at the court. These are requests for the court to hear cases. The U.S. Supreme Court has almost complete control over its docket, right? So some of the important cases that the court considers don't end up getting a whole lot of attention because the court decides to what's called deny cert. And in fact, the court just recently denied cert in some 2,000 cases that had piled up over the summer, and the law clerks worked on and presented to the justices, and they had a big conference at the end of September to decide which cases they would take and which cases they would deny. And they ended up taking 11 and denying 2,000, and some very important cases we're not going to talk about because they denied. And it tells you the power of the court is often not very public. So a very important controversy about choose life license plates, whether states may or must offer those to residents, to people who live in a state, right? Whether it's prohibited by the Establishment Clause or required by another part of the First Amendment, the Free Speech Clause. There was also an important case on the Pledge of Allegiance and a state policy concerning parental permission being required if a student doesn't want to participate in the Pledge of Allegiance. Again, the court denied cert in that case. And so a lot of action going on in the court behind the scenes, and what we're going to want to talk about today is a lot of the action that's going to be going on this year much more in public view, some of the more important cases that the court will be deciding during the present term. We can't cover all of them, and you would not be pleased with us if we tried. But I do have with us today some folks who can help us to understand just some of the more important issues that the court will be considering this year. To my immediate left, Ernest Young is going to be talking about an important Second Amendment case, as well as some other cases, some foreign affairs cases, also an important financial case, I think. Professor Jim Coleman will be talking about two very important Eighth Amendment cases that the court's going to be considering this term. And then to Jim's left is Professor Sam Buell, who's visiting us this semester from Washington University in St. Louis, who's an authority on criminal law and criminal procedure, and we'll be talking about some of the criminal cases on the docket this term. So without further ado, let us begin now with Professor Jim Coleman, who will tell us about these Eighth Amendment cases.
Okay, the two cases are both out of the state of Florida. One involves an appeal by a defendant who's now 33, but who was 13 years old at the time that he was indicted for sexual battery, raping an elderly woman. And at the time, he was sentenced to life without possibility of parole under Florida law. He served, as I said, he's now been in prison for 20 years, at least 20 years from the time that he was indicted. When the Supreme Court decided the case Roper versus Simmons in 2005, in which it held that the Eighth Amendment categorically barred the death penalty for juveniles under the age of 18, he filed a post-conviction motion to have his sentence declared unconstitutional under the Eighth Amendment for under the same rationale as the court had decided the Roper case. The Florida courts denied his post-conviction motion on two grounds. First, on the ground that it was procedurally barred, that he should have raised it sooner. And second, on the merits, the court held that Roper was limited to the death penalty and did not bar a life without parole sentence for a juvenile. So he appealed filed a cert petition in the Supreme Court from the denial of post-conviction relief and bypassed the lower federal courts. It could have gone into federal court on a habeas petition, but instead sought review by the Supreme Court. The court granted cert, and the issue in the case is whether, as they argue, that the logic of Roper dictates that a sentence of life without parole violates the Eighth Amendment. The Supreme Court, in applying the Eighth Amendment to sentences, makes a distinction between capital sentences and non-capital sentences. And the basis for that is that the court says that death is different, and therefore the court looks at a death sentence differently than it looks at a non-capital sentence under the Eighth Amendment. What Sullivan argues is that life without parole is also different in kind than a non-capital sentence for which there's a possibility of parole. And that's particularly true in the case of a juvenile for the reasons that the court in Roper said that a death sentence was inappropriate for a juvenile. That is, that a juvenile has not fully formed, that the person is susceptible to pressures, particularly from peers, to engage in bad conduct. There's a potential for growth and change, and that almost all young people grow out of criminal behavior. So the court said that in light of that, juveniles were less culpable than adults, and therefore should not be sentenced to death for crimes for which an adult would be sentenced to death. Sullivan argues that the same rationale should govern in the case of life without parole, and that the Eighth Amendment should also bar that sentence for the same reasons, that there is potential for growth and change, and that the behavior is something that most people will grow out of. The brief for the petitioner also looks at the statistics of sentences of life without parole in non-capital cases for juveniles. And although this case involves a non-capital sentence, what the brief does is to look at, it appears that they look at all sentences of life without parole, both, non-capital, I'm sorry, obviously non-capital, but non-homicide cases. So what they apparently do is to look at both cases in which a juvenile has been convicted of murder or some other criminal homicide, as well as cases that are non-homicide. And apparently in the country, for offenders who are under the age of 14, there are only 9 individuals serving life without possibility of parole. And if you add the 14-year-olds, there are only 73 such sentences in the country. The brief also makes a point that these sentences are not the result of a legislative judgment that juveniles should be sentenced to life without parole, but that it's the result of an interaction between legislation that makes it easier to sentence juveniles or try them as adults and therefore sentence them as adults, but also legislation that increased the number of crimes for which an adult could be sentenced to life without the possibility of parole. The state basically raises 2 issues, one of which the petitioner did not address in opening brief, which is that there was a procedural default. And what that means is that he could have raised this issue in 1990 when he was first sentenced to life without possibility of parole under a case called Thompson versus Oklahoma, in which the court had held that the death penalty was unconstitutional for a 15-year-old. So his argument is that, the state's argument is that, therefore, this Eighth Amendment claim could have been raised. If the Eighth Amendment bars the claim, though, then there is an argument that, in effect, he's innocent of the possibility of being sentenced to life without parole. But that then raises a whole new approach to the issue that's not before the court. The second case is also out of Florida. It involves a 16-year-old who pled guilty to armed burglary and attempted armed robbery. His sentence was deferred, and the court offered him the possibility of going to prison for 12 months, followed by a period of parole, and at the end of which the charges would be dropped. He took that deal with the understanding that if he violated the conditions of probation, that he would be sentenced as an adult. As soon as he got out of prison, almost immediately after, he engaged in criminal conduct involving the entry into a house, robbed the residents at gunpoint. As a result of that, there was a revocation hearing. The court, against the recommendation of both the prosecutor and the sentencing, whatever it's called, the sentencing board, sentenced him to life without the possibility of parole. He then appealed, lost, and so his case came to the Supreme Court, not through post-conviction, but direct appeal from the sentence and the revocation hearing. Just a couple of points about this. Apparently, it's very difficult to figure out how many people, how many juveniles have been sentenced to life without possibility of parole. But one empirical study that was done in connection with this case found that there are about 109 total juveniles in the United States who've received life without possibility of parole for non-homicides in all of the 50 states. 77 of those are in the state of Florida. 39 states have 0 juveniles serving such sentences, and only 8 states with confirmed data have any juvenile offender sentenced to life without possibility of parole for non-homicide offenses. Most of the people sentenced to life without parole who are juveniles are sentenced as a result of criminal homicide convictions. One other point is that 84% of the total non-homicide juveniles who are sentenced to life without parole in Florida are black.
Jim's looking at me. I'm not from Florida.
What do you got to say about that?
I'm going to change the subject.
Do something.
So I feel like a little bit of an interloper here because I'm not really a scholar of the Supreme Court, certainly in relation to a lot of my colleagues. But this is a very exciting term for me because the court is poised to possibly say more about the subject of white-collar crime than it has in a long time, and that's an area of intense scholarly interest for me. So principally, there are 2 cases on fraud before the Supreme Court this term. And specifically, they have to do with the bulwark federal anti-fraud statute, which is called the mail fraud statute. It's called the mail fraud statute just because the use of the mails, or now the wires, is what makes it a federal crime. But it's essentially an all-purpose anti-fraud statute. And it's been huge. It's created a huge industry of prosecuting white-collar crime in federal court by federal prosecutors for many, many years, an industry that's only grown in size exponentially in the last 10, 15, 20 years. So the court's poised to make a fairly significant potential intervention into this term with these 2 cases. And to understand these cases, you need to understand the distinction between two kinds of fraud. So there's a simple kind of prototypical fraud that we would all think of, that is, defendant lies to the victim and causes the victim to part with the victim's money and give it to the defendant. That's not what these cases are about. These cases are about a harder kind of fraud, and let me just talk about two sort of examples that you get a lot in this context. One involving, say, corporate officers would be, suppose that a corporate chief executive officer pushes through a merger of her company with another company, and her purpose in doing so is to get some big payoff from the acquiring company when the merger goes through. And she doesn't tell anybody that, it's not disclosed to anybody, and the question is, does that defraud the company, her company shareholders, because she's she's engaging in a corporate transaction which is designed to line her own pockets without anybody knowing about it. The other kind of example that comes up often in this context is the elected official who might kill a particular piece of legislation in order to get some later undisclosed job or benefit from a corporation that has an interest in that legislation. So this sounds a little bit like a bribery case, but for reasons having to do with bribery law, it might actually be very difficult to prove as a bribery case because the prosecutor can't prove an actual agreement, a quid pro quo, which is almost like a contract between the company and the legislator, that the vote or the effort to kill the bill would be accompanied by some future income. So those cases are also present a kind of difficult question of fraud. Has the legislator defrauded the citizens for whom she works of their right to have her do her job in an honest way if she engages in this conduct? Has the CEO defrauded the company's shareholders of their right to have the CEO do her job in a loyal and honest way if she's not disclosing her reason for wanting this merger to go through? This kind of fraud is what's come to be called honest services fraud in federal court. And the history of this thing, just briefly, is that the original mail fraud statute didn't have anything about so-called honest services fraud in it. It just said don't commit fraud, basically. And over time, the federal courts developed through judicial articulation of what the statute meant that don't commit fraud means also don't engage in schemes that are designed to deprive people of your honest services who are entitled to those honest services, like corporate shareholders or people who elect legislators. Supreme Court didn't like this theory a whole lot when it finally got around to looking at it in the mid-'80s and ruled in a case called McNally that was a wrong interpretation of the statute. There's no such thing as honest services fraud under this general fraud statute. Congress turned right around and passed a new statute saying, yes, there is. And the statute basically says a scheme to defraud includes a scheme to deprive someone of their intangible right to your honest services, defendant. And the courts went right back to working on explaining what that meant, including readopting all the cases that had preceded this Supreme Court opinion in the mid-'80s. This has now become a very controversial and hotly contested area of federal fraud law, and the Supreme Court has taken two cases now this term on the meaning of this congressional fix statute. That is, what does it mean to deprive someone of the intangible right to honest services? It's an appealing concept because of these difficult kind of fraud cases that don't seem to be addressable with a simple concept that if you lie to the victim and take their money, that's fraud and everything else isn't. But it's a very hard concept to limit. It's a very hard concept to define, and it leaves a lot of work for judges. So here comes the Supreme Court in two cases. One of them is called United States versus Black. This is an interesting case that they've granted cert because they actually have relatively infrequently granted cert in federal criminal cases that have been high profile. And the Conrad Black prosecution was very high profile. Big white collar prosecution in Chicago involving a guy who ran a company that owned newspapers. And he's actually Lord Black. He's been knighted. He's a Canadian who's been knighted in the United Kingdom and was convicted of criminal fraud and sentenced to a pretty stiff term in federal prison. His conviction was affirmed by the Seventh Circuit, an opinion by Judge Posner, and now the Supreme Court has granted cert on the question of whether to commit this kind of honest services fraud, does the defendant need to contemplate some economic harm to the victim? That's the question presented in the case. And here, what happened in Black's case was his newspaper empire was selling off all these newspapers. And pretty soon they only had one left. It was a little community newspaper in a town in California that had a population of 7,000 people. And at that point, at the point at which the company had this one little newspaper, it strangely entered into an agreement with Conrad Black that it would pay him a $5.5 million non-compete fee. That is, don't compete with this little community newspaper, Rupert Murdoch, which is essentially, sort of what he is, and we'll pay you $5 million. And that wasn't disclosed to the board of directors, and therefore, under corporate law theory, the shareholders didn't know about it, and so the idea is he stole from the company. Now, prosecutors prosecuted on both a straight fraud of property and an honest services theory, and both were submitted to the jury. He said at trial, in an argument that didn't, I guess, surface until the time of trial, well, what I was really doing was trying to defraud the Canadian government, because it was the blame it on Canada defense. It was really a management fee, but I didn't want to call it that because it helped me avoid taxes in Canada to call it a non-compete agreement. So I was trying to defraud Canada, but you charged me with trying to defraud the company, and that's not the same thing as Canada, therefore I'm not guilty. Judge Posner has some humorous comments dismissing that argument in the appellate decision. So the question here is, does Black have to have contemplated economic harm to the corporation in order to have been guilty of honest services fraud? The other case comes to us courtesy of Alaska Politics, about which we all know a lot more than we did a year and a half ago. So a legislator in Alaska, this is the public official fact pattern, a legislator in Alaska was involved in trying to kill some legislation that affected the oil industry at a time when he was planning on leaving the legislature. As an attorney, he was planning on collecting legal fees from oil companies after he left the legislature, and he started negotiating with an oil services company to get future legal work from it, while also talking to them about opposing this legislation that they didn't like. And he didn't disclose that to anybody, that he was working against the legislation because he was planning on billing these guys by the hour when he left the legislature. He hasn't been tried yet. The trial court ruled that he needed, in order for the prosecutor to proceed on an honest services theory here, again, the idea is he's not stealing from the shareholders. He's depriving them of the ability to, the voters. He's depriving them of the ability to know that he's corrupt, essentially. And so the trial court said, well, for the prosecution to prove this case, they've got to prove that it was a violation of some law in Alaska for him to have failed to disclose his relationship with this oil company. And it went up to the Ninth Circuit, and the Ninth Circuit said, no, they don't. They don't have to prove a state law violation. And the Supreme Court has granted cert on this issue, that is, in these public official cases, does the prosecutor have to prove that what the public official was doing was a violation of some state law regulating politicians, essentially, or government officials? And this has been an attractive kind of concept in some of the courts of appeals because, again, everybody's looking for a way to limit this honest services theory. It seems like a slippery slope. Does this really mean, for example, this statute, that any time a public official fails to disclose some conflict of interest to the voters, she's a federal felon? So everyone's looking for a way to limit this, and this sort of state law violation theory is one way to limit it, and I guess the Supreme Court is going to decide that question. So this is very interesting because it'll all tell us a lot about the meaning of this fraud statute that has been subject to debate and uncertainty for many years, unless the court doesn't tell us a lot, which sometimes it doesn't. But that's sort of what the anticipation is. And it's also interesting because of the way in which the Supreme Court has dealt with substantive criminal law in the federal courts in the last, 15, 20 years. There have been a series of Supreme Court decisions on substantive federal criminal statutes that have aspects to them that are vague. And the Supreme Court has decided virtually all of those cases on grounds of statutory interpretation, even though what's really going on in the cases, I think, is constitutional law. So what the Supreme Court does is it finds a way to interpret the statute to narrow it so that it doesn't have to say that the statute has to be struck down on constitutional grounds because it's unfairly vague. It doesn't give anybody notice of what's a crime or sufficient notice. And so that kind of dance is going to be going on again in these cases, except for the fact that Justice Scalia has now gone on the record in a dissent from a cert denial in one of these mail fraud cases, saying that this intangible rights statute is unconstitutionally vague. So he will be trying to persuade some of his colleagues to strike down this statute, even though that's not in the questions presented in these two cases. In my experience, that's not necessarily going to hold back the court. If he could get 5 votes to declare the mail fraud statute unconstitutionally vague, I think he would do that eagerly. Probably there aren't 5 such votes, especially because, you know, the betting at this point, and I tend to agree with this betting, is that Sotomayor is going to be more pro-government than Souter was on criminal law issues. She, in fact, was in the majority in a major en banc decision out of the Second Circuit a couple of years ago on the mail fraud statute, where the Second Circuit gave the probably what is now, I would think, is going to become the leading articulation in the Court of Appeals about what the meaning of honest services fraud is. It could actually end up getting adopted in the Supreme Court opinion in one of these cases. Maybe not, but it could. She was in the majority in that case in the Second Circuit, and there was a dissent in that case saying the statute is unconstitutionally vague. So I think it's very, very unlikely that Sotomayor would change her view on the statute now that she's on the Supreme Court. And that probably means that Scalia has 1 less vote, because I think Souter would potentially have been a justice who might have been sympathetic to the argument that this fraud statute is just too vague to pass constitutional muster. So that'll be interesting to watch. And I was also going to say some stuff about some Sixth Amendment cases that are on the docket, but I've used up my time. So if there's extra time and people want to hear about Sixth Amendment issues, I'm more than happy to address that.
Thank you.
Okay, so speaking of fraud, I always feel like a fraud when I talk about these cases that just came on the radar screen a couple of weeks ago and nobody really knows that much about yet. I'm a lot more comfortable, as many of you know, talking about cases decided in the 19th century, so you know, it's just a little bit too current for me. I'm also nervous about these kinds of shows because we always end up saying, well, the court is going to clarify the law in this area, or the court's going to clarify the law in that area, and I'm always reminded of a conversation with Judge Boudin, for whom I clerked, about Supreme Court review. We had this great little case about maritime law, actually, and there was a split among the circuits, and you know, the judge had issued his decision, and then we found out that the disappointed parties were petitioning for cert in the Supreme Court, and I said, well, you know, Judge, you know, maybe this area of the law is such a mess, maybe it may be good for the Supreme Court to actually take this case and clean it up a little bit. And the judge just bent over double, cackling. And it took like 5 minutes for him to recover himself. And he finally, you know, stands back up straight and he says, oh, so you think Supreme Court review clarifies the law? And there's something to that if you look at what the Supreme Court does with some of these cases. The big case on everybody's mind, I think, is the guns case out of Chicago, so in McDonald versus City of Chicago. And the question in that case is, you know, a follow-up question to the Heller case, which recognized an individual right to bear arms in self-defense. And the question, that was a case out of the District of Columbia, so it was the federal government that was restricting handguns in that case. You know, McDonald's is a case from the states. And as many of you know, the Bill of Rights does not apply directly to the states. It applies to the federal government. Most provisions of the Bill of Rights have been incorporated so that they apply to the states through the Due Process Clause of the 14th Amendment. But the Second Amendment is one of the few aspects of the Bill of Rights that has never been held to be incorporated so that it applies to the states. And so the question presented in McDonald is whether the Second Amendment will in fact be incorporated to apply to the states. And I think that's going to be a really interesting question because you can see pretty decent arguments both ways. On the anti-incorporation side, I think I can see 2 pretty good arguments. One is that, at least in the understanding of the dissenters in Heller, and this only got 4 votes, so maybe, you know, it may not be able to attract any more than that. The Second Amendment was primarily a federalism provision meant to restrict the federal government's ability to control the militias, which were organized primarily at the state level. And if you think of it as a federalism provision, and it may be that, you know, the dissenters can pick up a vote or 2 on that question when we get to the issue of incorporation, simply because the justices in the majority in Heller were also the justices who tend to be most sympathetic to federalism arguments. So if you think of the Second Amendment as a federalism provision, then incorporation would be a strange thing to do. There's also the traditional test for incorporation, which is that we only incorporate those rights against the states that are part of fundamental fairness, right? The Due Process Clause does not say anything as categorical as the Bill of Rights applies to the states. It says that the states cannot deny due process of law. And the court has been quite clear about saying that the only rights that are incorporated are the ones that can meet the traditional test of substantive due process. Is this an element of fundamental fairness? Is it so rooted in the traditions of our country as to rank as fundamental? Can you imagine a fair legal system without this right? And given the fact that the court had never recognized an individual right to bear arms in self-defense until, well, Heller, it's hard to say that this individual right to bear arms is so rooted in the traditions of our country. And so I think there are answers to that argument, but I can imagine that persuading some justices. On the other hand, the interesting thing about the historical debate in Heller itself was that the evidence for an individual right to bear arms got better the further toward the present that you went in history. So if you look at the founding period when the Bill of Rights itself was ratified, there's not all that great evidence that the framers of the Second Amendment itself contemplated an individual right to bear arms. They were much more focused on militias. But as you move toward Reconstruction, which is the relevant period for interpreting the 14th Amendment, the framers of that amendment, or the generation that framed that amendment, seemed to view the lack of individual rights to bear arms among the freedmen and their consequent inability to protect themselves from both the Klan and hostile state governments. They seem to view that as a critical component of the right to bear arms. And so the case for an individual right is better in 1868 than it is in 1791. And that could be a very important fact for incorporation. So that's McDonald. Let me talk just briefly about the foreign affairs cases on the court's docket. Most of the attention is going to Holder versus Humanitarian Law Project, which is a case about the material support for terrorism statute. And it's a vagueness challenge. Much like Professor Buell talked about some other vagueness challenges to other federal statutes, and I tend to see that as less a foreign affairs case and maybe even less a case about terrorism than a vagueness case. But I think two other cases will tell us something about how the court in its new configuration views foreign affairs issues, views the place of international law in the domestic legal system, views the place of comparative law in the domestic legal system. And so that should be terribly interesting given the change in the court's personnel. So Samantar versus Joseph, which I'm quite sure I'm mispronouncing, is a case about whether a foreign state's immunity under the Foreign Sovereign Immunities Act extends to officials acting on behalf of the state. So, for instance, the Foreign Sovereign Immunities Act clearly makes it very difficult to sue foreign governments. Most of the circuits had interpreted that immunity as not extending to the officials of the foreign governments. So, for instance, there's this slew of cases under a 1789 statute called the Alien Tort Statute, which allows people who've been the victim of human rights abuse in another country to sue their torturers or their oppressors if they can get personal jurisdiction over those people in this country. And it's amazing how many torturers in the third world seem to retire to New Jersey and then become subject to personal jurisdiction in American courts. And so there's the statute has been an important means of vindicating international human rights. If the immunity of the foreign government extends to their officials, then that's going to put a damper on that sort of litigation. And the other case I think that will tell us something about the new court's attitude toward foreign affairs are these juvenile offenders cases and the life without parole cases that Professor Coleman's been talking about. Because the big question there for me is, will the court look to foreign law and foreign practice in determining how to treat these cases under the Eighth Amendment? Roper versus Simmons, which is the inspiration for these cases, that's the juvenile death penalty case, was a very important case about looking to foreign law in order to construe the Eighth Amendment. And it'll be interesting to see whether they do that in this case as well. The last case that I want to talk about is a business case, and I usually have no idea about business cases, but this one happened to be argued by me in the Seventh Circuit because I was desperate to get to do an argument and was willing to take just about anything. And thankfully, one of the questions presented is not whether it's fraud to have a con law professor argue a securities case. The question in Jones versus Harris is how does the Investment Company Act regulate the compensation of mutual fund advisors? What restrictions does it put on the amount of compensation that a mutual fund advisor can take from the fund? The reason we have a statute that regulates this is that there's a very strange relationship between the people who give advice to mutual funds and the shareholders in those funds. And that is that the funds are created by the advisors. And you're an investment advisor, you say, I want to have a mutual fund, so you create the fund, and then you have the fund hire you to provide services, picking the stocks and all that, and then the fund compensates you. But there's not really an arm's length relationship between the fund and you, and they're basically able to set their own fees. And there's also not a competitive market, at least with respect to the fees that the advisors charge. Funds compete based on their performance, but they don't compete based on the funds that they charge. And so Congress had regulated that and imposed a fiduciary duty on the advisors to the fund not to take too much from the fund. And the question is, what is the right standard for evaluating whether that duty has been breached? And the reason this is an interesting case to me as a common law professor is it's really a private law analog to the situation we get in public law cases too, which is allocating authority among different institutions as to who should make a decision. So who should say whether an advisor's fee is too large? Should it be the advisor himself? Should it be the board of directors that may not be all that independent? Should it be an administrative agency like the SEC? Should it be a court simply reviewing whether the fund is too large? And that's really what the court has to decide. I think also this case will be a barometer for how the court is likely to respond to issues of financial regulation in the wake of the economic meltdown in those markets. And just so you know, we will have a public moot on that case on October 21st, so hopefully some of you can see David Frederick, who's arguing for the plaintiffs, practice up for the argument in November.
Well, thank you. Thank you very much, Professors Coleman, Buell, and Young. And I want to open it for questions, but before I do, I just want to mention briefly some other important cases that the court is going to be considering, just so that you have it on your radar. So we recently had a moot in the Stevens case, which was just argued this morning, right, concerning a federal criminal statute that prohibits commercial trafficking and depictions of animal cruelty, and whether or not it's consistent with the First Amendment for the federal government to prohibit such speech. Very important First Amendment case. Will the court create a new category of speech that is categorically excluded? If it does not, will it nonetheless find that there's some other reason that could support federal regulation? Or will the message be that you've got to target the conduct and not the speech? So a very important First Amendment case. Also an important standing/establishment clause case. So one area of constitutional law in which I think the court is going to move significantly is in the area of the establishment clause. I think the court is going to allow, now that Justice Alito has replaced Justice O'Connor, much more in the way of public expression of religious beliefs, symbolic religious expression. Justice O'Connor was very concerned, and she controlled the court, about whether, say, the presence of a cross on public land would be viewed by the reasonable person as endorsing religion. Justice Kennedy, who I suspect is going to be in control now, didn't concern himself with endorsement. He was just concerned whether or not there was coercion of religious belief. So he could be concerned about a school prayer at a high school graduation under certain circumstances if he thought young people were being coerced, but merely the presence of a Ten Commandments display or a cross, right, in his view, not particularly coercive. The Salazar against Bono case concerns a large cross that was originally on public land and was moved it's actually the land itself, the cross wasn't moved, but the land itself was made private to avoid an Establishment Clause challenge. Right? And the question in this case is, does the person challenging the presence of the cross there, does the person have Article 3 standing to make the Establishment Clause challenge? And if the person does, right, does government alleviate the Establishment Clause problem by transferring the religious display to private land? So I think it's the court could get rid of the case on standing grounds, which itself would be a significant move in standing law. But it also may be the first of what I suspect will be a series of cases in which you see much less of a wall of separation between church and state on the Roberts Court than existed on the Rehnquist Court. Another case I wanted to mention very briefly is Citizens United. This was on the docket last term, and instead of deciding it at the end of the term, the court set re-argument, which took place on September 9th. So it's technically part of last term's docket, but it's going to be coming down this term, and this concerns whether federal campaign finance laws apply to a film critical of then Senator Hillary Clinton, and was intended to be shown in theaters and on demand to cable subscribers. This was Hillary the movie. What's very important about this case, the court could have decided the case on relatively narrow grounds and protected showing the movie. Instead, the court set re-argument and asked the litigants to brief the question whether some very important and longstanding campaign finance precedents, one of the cases has been on the books for almost 20 years, should be overturned. And the question is whether corporations, right, have essentially the same rights to spend money to influence the outcomes of elections as private individuals do, or whether corporations are in an important sense special, and that government can prohibit them from using their own general treasury funds, right, to make independent expenditures to try and influence the outcome of elections. So how does the court conceive corporations under the First Amendment, right, like private citizens, or importantly different? I strongly suspect the law is going to change significantly in this area. There's a good chance it'll happen in this case, and I think it's going to be happening in the years ahead as well. Let me stop there. There are other important cases. There's an important challenge to federal power, the first on the Roberts Court, the Comstock case, which you can look up if you're interested in. Some important other business cases, a very important patent case, the Bilski case, about what's patentable. Does it have to be a machine or a transformation of an apparatus, or can it just be a method of doing business? Right, very important case concerning patent law. But let me stop there, and we have a good 20 minutes, and let me open it up for questions. I have questions I can ask the panelists, but I would prefer it if you folks had questions about what you've heard or anything else broadly related to the Supreme Court that you'd like to know more about. Yes.
Chief Justice Roberts' confirmation hearing, one of the things he pledged to do was increase the number of cases that the court was hearing. I haven't seen that happen yet. Is there any indication that he's not doing that?
Well, please.
Well, he can't do it on his own, right? And these other justices, they're pesky, right? They don't necessarily do what the chief says. One thing that he did do was pledge to increase the number of business cases. And that you do see in this docket. Jones versus Harris is the tip of an iceberg. I mean, I think half the docket at one point was business cases. So at least as a matter of subject matter shift, there's been a shift. But it's, you know, and it'll be hard to tell. We won't have the full docket for this coming term until January, right? So it's hard to know, you know, whether there'll be more.
And for this coming term, the court in recent years has been deciding, it really depends on how you count. It gets complicated, how many cases exactly. Some cases are consolidated, right? Some are briefed and argued but not decided. They've been deciding around 75 to 80, right? Last term was 79 total, 75 after briefing and argument. So far this term, again, depending on how you count, is around 55. And so the docket is more than likely a little more than 2/3 full. So part of what we'll be seeing in the coming months is not the arguments and the decisions in these cases, but as well as some more cert grants, right? The court will still be taking some more cases and filling out the docket. I certainly agree with Professor Young that no one justice can do it alone. And it's also, you know, it's not entirely clear to me that the court ought to be taking a lot more cases. I think there's an appearance problem and a public relations issue, and I think the justices are self-conscious because they've been criticized a lot for it. I don't know that they understand why it's been harder to do. They don't see themselves as sitting as a court of error correction, and if they did, they'd be taking thousands of cases, right? It's about splits of authority on important questions of federal law. And unless someone can show that there are splits of authority on very important questions of federal law that the court is not getting to, right, then it's not clear to me that the court really ought to be deciding a lot more. It's just, I think, an empirical question in that regard. Other questions, comments, concerns? Yes.
I'm actually curious about the issue of standing in the honest services line of cases. Did anyone ever challenge whether, I guess, a taxpayer or constituent can raise these sorts of?
Well, standing is not really an issue in criminal cases, because you're either the defendant or you're not. And so, if you're getting prosecuted, you get to litigate. If you're not getting prosecuted, you don't get to litigate. And so a citizen can't come in to a criminal case and say, I don't like the way this statute, I mean, it's interesting in the sense that, a big category of arguments that get made about in the line of a statute's too vague, like the honest services statute. If you look at what the Chamber of Commerce, for example, has been saying about that law, a big category of arguments is bad for business. It chills risk-taking behavior when we have this uncertainty around what counts as fraud. And so, we ought to define this more narrowly so that business people can go about doing all that great wealth-generating stuff that they do and not be holding back for fear of federal prosecution. But you don't get to actually intervene in a criminal case and make that argument as a litigant. And what you do get to do is you can file amicus briefs with the Supreme Court. And the Chamber of Commerce has actually become, among other organizations, has become much more active and coordinated and strategic in the way that it has begun to act as a friend of the court in criminal and civil business cases. And I haven't looked at the amicus briefs yet in the mail fraud cases. I'm sure a lot of them aren't even in yet to see who's in there. But I'm quite sure that there'll be business-related interests that'll be filing briefs with the court, sort of trying to take a step back from Conrad Black's issue or the legal instructions in these cases that are the question presented and say, this mail fraud statute's a problem for business and you really ought to narrow it for that reason. Not having clerked on the court, not being a student of the court, I can't give you a sense of, where amicus briefs stand these days in terms of how persuasive they are. I mean, it's interesting that Neil said that, talked about how the Roberts Court is making this very concerted effort to, do more in the business area. And so the question is, in doing that, are they going to be giving a hearing to kind of, business interests that are attempting to be heard in cases not as litigants in ways that they, are greater than they ordinarily would for people in the friend of the court posture?
Yes.
The court does rule that the states can't deprive people of rights afforded under the Second Amendment. I was wondering what sort of the implications are for the other rights in the Bill of Rights that aren't already incorporated into the due process clause, if any, if there is any implication.
I'd say that if you're a state and you're quartering soldiers in people's homes, then I'd be worried. Right?
He always makes fun of my favorite amendment. I don't know why he does it.
There aren't many, right? Because I think even though the court has always said, we're going to incorporate based on this fundamental fairness calculus, it's just so clean to say, well, if it's important enough to get into the Bill of Rights, it's important enough to be part of fundamental fairness and incorporated against the states. So just as a matter of intellectual tidiness, just about everything has been incorporated. So what's not incorporated? The Second Amendment so far, the Third Amendment, jury trials, grand jury trials under the grand jury indictment, and then the Seventh Amendment, right? Not incorporated either. Now, I think the big one there is the Seventh Amendment, but I'd be surprised. I mean, it's just such a different debate, and the court hates the Seventh Amendment. So,
my first cut at your good question is that I don't think there's going to be much in the way of implications at all. I think it's it's really, this case is about the Second Amendment, much more than it's about incorporation.
Follow up then. So you don't see any type of reinterpretation of the Privileges and Immunities Clause coming as a result of?
Well, that's one of the ways in which it could be incorporated. So the question presented is, should we use the Due Process Clause or the Privileges or Immunities Clause of Section 1? Yeah.
right. And that, it would be interesting if they chose to use the Privileges and Immunities Clause, would that then be a way to revive the Privileges and Immunities Clause for other things?
Right.
That would be fascinating. That would get a lot of law professors tenure to write about.
Are there any indications how the animal cruelty free speech case went this morning?
There must be. And I could tell you what they are within the hour, right? I'll go on SCOTUS blog. That's what I would do, is go on SCOTUS blog, and you'll get a take, a quick take, and then a less quick take later on in the day. The transcript will become available, right? But I think it's a great question. I just it's something that deeply interests me as well. Yeah. I wanted to ask Professor Coleman a question, and it's an unfair question, and you can tell me.
That's okay.
To go, to go various places, but, Justice Kennedy has clearly been driving the court's Eighth Amendment jurisprudence in the capital context. I strongly suspect he's going to be driving the outcome in the two cases you discussed. Any sense you don't have an X-ray, right? I'm not sure he knows, and he moves, right? But just any sense of how he's likely to, or more likely than not, to respond to the cases?
Well, I think it probably will be significant to him that the sentences were not mandated by state law. In other words, it is the result of juveniles being tried as adults, as opposed to a statute that authorizes this sentence specifically for juveniles. In his opinion in the three-strike law, that was a factor that he identified, that it was mandated, that life sentence was mandated for 3 strikes and you're out by the legislature. So, if he thinks that's significant, I think that might make a difference. It's hard to know. It's also hard to know whether the court will, you could get different results for the 13-year-old versus the 16-year-old. I don't know. I would think that they would be more troubled by the 13-year-old than the 16-year-old. But on the other hand, the procedure under which the 13-year-old was charged was an indictment, whereas for the 16-year-old, it was an information filed by the prosecutor that's not reviewable. So, that process might create some concern. On the other hand, a decision will have implications way beyond just life without parole, and I think that's going to be the concern. How broadly in a decision in favor of the juveniles would impact the criminal justice system. It could have extraordinary impact.
Thank you. We've got a few more minutes. Anyone? Yes.
Another Second Amendment question. If it is incorporated against the states, will then all the states have to follow a radically different federal policy on gun rights and gun laws? Is there going to be a lot of fallout if that happens? A lot of a massive across-the-board change in gun laws?
You want to take it, or should I?
There's going to be this great period where it all seems open, and people are going to write lots of interesting articles and file lots of interesting complaints about what kinds of gun laws are acceptable and what parts aren't. And that's going to be fun. I suspect the way it shakes out is total bans are unconstitutional and just about everything else is okay. And it'll get boring again as that becomes clear. But, the last confident prediction I made about what the court would do is that they'd never take Bush versus Gore. So,
I think it's an important question, right? Because if the court holds, as I strongly suspect it will, right, that one way or another the Second Amendment has been incorporated, then it's not just about federal gun control laws, right? It's about state and local gun control laws. Now, you wouldn't say it's going to have huge national importance. I think Heller makes no practical difference in about 42 states, right? Because of, at least it seems that way, because of the state, right? The state Second Amendment regimes that are in effect there. It's really primarily in urban areas and even more specifically high-density, right, high crime urban areas that have the more restrictive gun control laws, right, where Heller makes a real difference, not just with respect to D.C., but now with respect to Chicago and San Francisco and New York and Detroit, right? That's where I think the biggest practical difference is going to be. How much of a difference is going to probably be decided not by this case, but by the next series of cases in which we learn what Heller actually means, right? Justice Scalia, at the end of his opinion, has a list of reassurances, right, in which he tells America, right, a series of what I call don't worries, right? All sorts of reasonable regulations are okay. He doesn't tell us why they're okay, right, or how the history permits them, but he says all these reasonable regulations are okay. Carrying guns in dangerous places, right, reasonable licensing regimes, particularly unusually dangerous weapons, right? So but we don't know exactly what that's going to mean. We don't know what the standard of review is, right? The court in Heller didn't tell us what the standard of review is. I doubt they're going to tell us in this case, because this case is about incorporation. So we're going to need to learn a lot more, and I suspect, we're going to end up in a place in which reasonable gun control regulations, which is basically the regime that the states have, are going to be okay. Now, what exactly do you mean by reasonable, right? That's going to have to be fleshed out, and I imagine the Heller majority is going to splinter over some of those questions that will arise. Okay, yes?
Professor Coleman, you cited certain geographical and racial disparities with regard to life sentence without parole for minors.
Mm-hmm.
In your opinion, do these disparities present prima facie evidence that life sentence without parole for minors is cruel and unusual punishment, or only that it's been applied unfairly?
No, I mean, there are two approaches that the court takes to Eighth Amendment cases. One is whether the punishment is inconsistent with evolving standards of decency. And there, the court counts the states, sort of what are the states doing, how do they add up. The other way that the court does it is to determine whether the punishment is disproportionate to the crime. That's how it does non-capital Eighth Amendment cases for adults. So the question here is going to be whether the court will take into consideration age as a factor in doing a proportionality analysis. It could do that. It could say that although life without parole for an adult convicted of sexual assault is not disproportionate, it doesn't violate the Eighth Amendment for that reason. Taking into consideration the juvenile and characteristics of a juvenile, that it might make life without parole disproportionate.
Is anyone else not asked? We'll have time for anyone more. Go ahead.
Just wondering if any conclusions can be drawn yet about the policies and positions of the new administration and the Justice Department and how they're approaching cases and what they're writing in their briefs.
There's someone I'd like to ask who's in the room that I can't, which is Professor Schrader, who we hope is going to be joining the administration sometime soon. But I don't know enough to know. I haven't read enough of the briefs, and I certainly don't know anything about litigation strategy to be able to tell you. I think it's a good question. I think initially what you see when administrations change is trying for there to be continuity, right? And then over time, when the administration has more control over its own cases, right, that there's more of an independent approach, but I couldn't say more about exactly what the, Solicitor General Kagan's approach has been, or Attorney General Holder's, or the President's. Does anyone have more specific information about?
I mean, I would just say in my area, I would expect little change, but I could be wrong about that. I mean, I was in the Justice Department during most of the Clinton administration and a good piece of the Bush first term, and I didn't see any real change. I mean, in criminal cases, the government always asks for the interpretation of the law that will help the prosecutor prove the case, and I don't, the Justice Department tends to trust its own prosecutors a lot, and there's some good reasons for that. There may be, some question as to whether the trust has been misplaced at times, maybe recently, but I haven't seen any administration sort of say, for example, in some of these cases that I was talking about, we ought to go to the court and suggest a narrower reading of the law because, the current law gives prosecutors too much power. So I would not expect a lot of change, but, maybe the new Attorney General has a very different view about that I'm not aware of.
I was somewhat surprised to see the SEC and the Solicitor General coming in on the side of the plaintiffs in the securities case. That may be, suggest a trend toward more vigorous enforcement in those areas, but I'm not sure the last administration would have done that.
Okay, Professor Buell is going to have the last word.
I was just going to say the department has announced that it's doing a complete top-to-bottom evaluation of its policy on sentencing, which could range from everything to asking for different legislation to taking different positions at the trial level or on appeal, and all of that is pending, right? That would be an area where they've articulated the need for a complete reevaluation, but not told us what they concluded. Stay tuned.
Well, I want to thank Professors Coleman, Buell, and Young very much. And I want to shamelessly peddle another event we're going to be having tomorrow on the role of the Supreme Court, rhetoric versus reality, and with Professor Young will join us again, as well as Don Ayer, who's teaching Supreme Court litigation clinic this year. Take care.